of or assist in administration of justice. So CUC is on the ground level, and it has almost carried the same membership of NCAJ to the lower level. And the main function that I know of, and especially from my experience, is helping in the administration of justice, because like on the ground, you have, I can just give an example, you have an OCS. An OCS must ensure that those ones who are in police custody are delivered on time to court to take place. That's an example I'm giving. You also find that on the ground we'll have prisons officer, and they are the ones who will be able to bring remandees on time to court. So the core function of CUC is to help in administration of justice so that we can have cohesiveness.
Thank you, Council. The 2005 final CKRC report, which you signed, interestingly recommended the establishment of village elders tribunals to hear and determine land disputes, and hear and determine matters of personal law. Might you want to tell us the rationale for that recommendation? And then after you've done that, can you tell us what the judiciary has done that is akin to that situation since the 2010 Constitution?
Yes. The precursor to this CKRC, we call it a draft, the 2005 draft, was after collecting views from all over the country. We went as far as Turkana, Wajir, wherever. We even came, I remember we were even outside here, we came here to take the views of the judiciary. And when we sat down to collect the views, after collecting and all that, we collected the views. What came as one of the major issues of dispute resolution, actually this is mostly part of what we wanted we wanted to have it as part of dispute resolution, was in the villages mostly, and that is where we find the majority of the consumers of justice. In the villages, there are so many ways that they can do their own disputes in terms of regulating their own affairs, including land and also personal laws. And I had mentioned earlier how even they could be able to regulate boundaries. They still do it. I know of some groups that do it. So the land dispute tribunals, we've been having them, I think, for a long, long time. We've been having them in our legislation. Yes, we used to have it. I'm not so sure right now. In a way, it involved the provincial administration then, and maybe some women representatives. We say public, they could pick some members of the public, and they will sit down and agree on how disputes on land were going to be dealt with. But yes, I think it's been done away with, because after that, I think that is the second limb of your question, my lady, is that we have ELC, which has the mandate to do all this irrespective. On the second limb of personal law, how we arrived at that, it was very pertinent that some communities wanted to do their own things differently, as long as the rider it's not repugnant to justice and morality, and it's not against the written law. And we were able to come up, like even, for example, what we have even right now in our constitution, we were able to come up with Curtis courts. I remember there was a lot of fightings, those ones of why should we have it. But generally we agreed and we said, here, there's no problem. This is personal law. If they have their own way of solving it, so let it be. Let them solve their own personal laws, that is marriage, divorce, I think also inheritance. Can we leave it to them? Yes.
Okay. Are you done? Sorry.
It's okay.
All right. Inside the judiciary, we have something called the alternative justice system. Would you know what that is?
Yes, I do.
Okay.
My lady.
Council, please tell us what it is and how it works here, the role it plays, please.
Thank you very much, my lady. First, I must start by congratulating you, because I didn't know that it had come into fruition. Sometimes back, I think it was being debated upon quite a lot. Alternative sorry, was it AJS?
Yes.
I think it is to do with encouraging communities and members of our holistic society to try as much as possible to solve disputes using their own traditional way or customary methods, as long as it does not go against the norms of what I've been saying. That is not repugnant, it's not against the written law. And I believe if that is what has come up, then the backlog of case backlog will really go down.
Have you seen our policy on AJS?
No, I've not seen it, my lady.
All right, we launched it just the other day.
Thank you.
Do you know the difference between AJS and ADR?
Yes. I may talk very well about ADR because it's more or less structured. We have arbitration, we have mediation, we have negotiation. But then when it comes to AJS, since I've not seen your policy, my lady, I may not really want to say so much about it.
All right. And I understand, and you're quite right there. But let's go to something else. As Chief Justice, Council, you would be our team leader, and the link between us and other organs of state, including county governments. Now, you told us earlier that you are a county attorney?
Yes.
Good. Now, what did you acquire there that would enhance your link between us and the county governments? Let's just remain with the county governments.
Okay. The link, my lady, is very well pronounced, not only in the Constitution, but also in the legislation. It's very important. I mean, the judiciary cannot live as an island on its own. It must be able to interact with the other links, whether it's the links of the government or the way also you've told me, you lady, that also with the links in the county government. The link is very important because let's say judiciary on its own cannot stand on its own without being with the others. And if that one happens, then it is bound to fail. It's very, very important. Only that the overriding factor, my lady, is independence of the judiciary must be safeguarded altogether. But does not mean that when you link with the other arms of government or also the county government, then that independence is eroded.
Would council know, we are still on the same thing, so yes, whatever you wanted to say now, you can continue saying. But we are looking for your knowledge of what we have done with county governments,
yes,
administratively to support them, and what they have done themselves to enhance the performance of the judiciary in access to justice, because that's our core mandate.
Most obliged. Thank you, my lady. What came into my mind, definitely, that is the first thing is I remember there was a circular that county governments should be able to provide at least land for purposes of enabling the judiciary to put up structures, court structures. And that was a good gesture, and I know most of the counties, including also Elgeyo Marakwet, as I'm speaking right now, has already ceded out land to the judiciary so that it can be able to build structures. And the other thing that also came to my mind sometimes back is once the county government has ceded out land to the judiciary, it will also be upon the county attorney of that county and also the judiciary legal team to ensure that that property is registered under Judicial Service Commission, so that we don't have a situation where maybe with the time, if there are any altercations, it will be, the judiciary, the judicial officers in the locals might be kicked out. So that is also another very important part, apart from ceding out land, also ensuring documentations are properly done. That will be a very important link. And the other one, my lady, is communication is key. Even this perception we have in the judiciary as maybe we don't work, or that is as that judiciary does not work optimally, the backlog, the bad name that comes here, we could use that channel, because the county governments have a very good channel of communication. Communication, not only in the sense of holding barazas, but also, disseminating issues from the county to the ward level, to the sub-ward level, all the way to the village. So you'll find even the common mwananchi in the village there would know what judiciary is doing if the judiciary can be able to take advantage of that communication system that decelerates to the people on the ground.
Thank you, Counsel. If you come in here as Chief Justice, you would automatically be the President of the Supreme Court. One of your leading roles there is to lead as the jurisprudential head of the entire institution. And therefore, in respect of jurisprudence, we would not get a better person than the Chief Justice. You will find 6 co-equal judges as far as jurisprudence is concerned, and you will be the team leader. Please explain to us what you see, listen to my question, as the role of a dissent judgment in a collegial court such as the Supreme Court.
Yes, thank you very much, my lady. Yes, as I'd said earlier, as President of the Supreme Court, being the Chief Justice, a Chief Justice is first among equal. When it comes to decision making, the Chief Justice is not at a higher rank than the others. So what does it call for? It calls for honest, fair decision making amongst all the sitting members of the Supreme Court at that particular time. And once they have, before even they can concretize their own decision making, maybe they would call for a conference and discuss issues.
Sorry, let us remain with the issue. The issue is your view on dissent judgments from a collegial court.
Yes, ma'am.
There's something we are looking for.
Yes. So, my lady, once they've agreed and there is a dissent from one of the judges, then of course the same is recorded. And it is very important because this is part of building jurisprudence. Dissent does not mean that you're not happy with what your colleagues have done. You also, this other judge is coming up with how they feel and think this matter should have been adjudicated upon. So for me, it is very clear that even this dissent maybe in future could be the reigning or could become reference point towards achieving better jurisprudence because society is dynamic. They could be, the dissent of today may not be the dissent of tomorrow. It could actually be the precedent of tomorrow.
Thank you.
Yes.
We've had critique of the Supreme Court as being the court that has created for itself unlimited appellate jurisdiction. Unlimited appellate jurisdiction. What would counsel say about that critique? Is it in fact a critique or a criticism? And what is the truth or otherwise of the original statement?
Yes, my lady, I think also this one is a matter of discussion and conjecture. Because when I look at that, what comes to my mind immediately, some case that the ones who criticize what the Supreme Court did are saying that there should be an end to litigation at some point. I think this is a new case, though I've glossed over it. I was not part of it. And from what I followed from that case is Section 35 of the Arbitration Act. I mean, towards bringing an end to litigation must end at the High Court. But after the High Court, the matter ended at the Supreme Court. So,
is counsel saying that the Supreme Court had no jurisdiction to hear mutual?
No, my lady, I'm coming from the point that you asked me about the critics, the criticism and all that. That is what came out. But I'm not saying that Newton case was a bad decided case. No, I'm just mentioning.
And that's not the issue.
Yes.
I think we must stand guided. You have said something about Section 35. The question is, arising from what counsel has just mentioned now, is whether the Supreme Court in fact had jurisdiction to hear the issues raised in Newton.
My answer would be definitely yes.
Because we're talking about unlimited appellate jurisdiction. That's what we are addressing right now.
Yes, it had the right because...
Okay.
Can I explain further?
Yes, of course.
Yes.
Of course.
Because on issues of interpretation of the Constitution and issues of general public, then it has jurisdiction to hear those matters.
Yeah,
so for me, yes.
No, you're quite right there, but the issue is we have this category of justice consumers. The one part says this court has created for itself unlimited appellate jurisdiction. Now, we are asking you not so much your view as to whether that statement is indeed correct, but where it comes from. Any person who says that, what would be bothering them?
I actually don't think that the Supreme Court does not have that unlimited appellate jurisdiction. It does. And to answer it shortly, my mind comes to what would it be that may want other or may call for criticism, is the sense that when we look at, sorry to go back to arbitration, my lady, when you look at that arbitration issue, it's like this is a commercial dispute. If it's a commercial dispute, maybe parties would want to clear with it, finish with it, and move on and do other things. But when now the critics or criticism that I hear from that is by taking it all the way to the Supreme Court could be time consuming and waste of money. And that is where I come from, not that I'm saying or I would agree with those criticisms.
Thank you, Counsel. Let's put the question differently. What is the jurisdiction of the Supreme Court?
Yes, the main ones are to hear or to hear petitions, presidential petitions, which is the original jurisdiction. Secondly, to hear appeals on interpretation of the Constitution and issues touching on matters of public importance. The other one also is to hear, apart from petitions, I think that one, yes, when I say apart from the petitions, that is matters of public importance, interpretation of the Constitution, and also to hear appeals from the High Court.
Thank you, Counsel.
Yes.
Back to you, Chair.
Thank you very much, Commissioner Acting CJ. Thank you very much, Counsel. And now we go to Honorable Commissioner Judge Wasame to continue with the questions. Judge, please.
Thank you, Professor. Counsel, from your CV, you said you have worked with the county, you have been a county attorney for Elgeyo Marakwet.
Yes, my lord.
And you have dealt with a lot of legislations, as you said.
Yes, my lord.
The biggest threat to devolution is the county assemblies.
Yes, my lord.
And the way they undertake impeachment of governors.
Yes.
Tell us two ways in terms of legislation proposals you will give governors or the Council of Governors to insulate them from this persistent and consistent impeachment motions filed?
Yes, it's true, my lord. County assemblies have been the guillotine houses for most of the governors. One of them is on the issue of accountability by the county governments also. I think a legislation should come up wherein the county governments are made to be accountable for the money they're using the county assemblies are made to be accountable to the money they're using in the county assemblies. That's very important, because that will make them also know that in as much as they're watchdogs as against the county government, they should also be watched. I don't know whether they're getting each other.
Yes, you're there. Again, another problem I find in this impeachment, it talks about whenever a vacancy arises in the office of the governor through impeachment, or the office of the president. For the office of the president, the deputy takes over for the remainder of the term. And for the office of the governor, the deputy governor. What is your view on that constitutional provision? The fact that, you know, we have elected our president directly ourselves, we have not elected the deputy governors, and we are giving them fruits on the silver platter. Is it time to change that legislation?
My lord, that's a very emotive issue, and I think it's in the public outside there. The discussion is very live, and I'll be a bit uncomfortable giving my opinion on that.
Yes.
It's a very live discussion.
Yes.
Yes.
Again, under Article 193, a governor is not eligible for re-election. In terms of 193, for example, and I take this very important, 193(2), I think this is the one which deals with impeachment, has been found in accordance with any law to have misused or abused a state office or a public office, or to have contravened Chapter 6, is not eligible, among other things. But the most critical aspect which I want you to address is this, which is 193(3), which says a person is not disqualified under Clause 2 unless all possibility of appeal or review of the relevant sentence of the decision has been exhausted. Now, this is my question. For you to exhaust the appeal process, the review process, and to overturn the decision of the Senate, both as a sitting president and as a governor, there shouldn't be a situation whereby you are removed today, maybe at 11 p.m., and the following morning you find somebody in your office before you have exhausted the review process, the appeal process, and the sentence has not been set aside or confirmed, the decision. Now, is it time, because the Constitution is not clear, time for us to give governors maybe 14 days, maybe 30 days, to exhaust that appeal process or review process, either for the sentence to be, or the decision to be overturned or confirmed in terms of timelines of the impeachment process?
Yes, my lord, I would want to answer it this way. Yeah, it's a very tedious process, and especially after the Senate, then to the court, and all that partakes to the point of having exhausted all the channels. My My Lord, I think also that is the reason why these courts are really clogged with so many cases, because things don't seem to move as per what is provided for by the Constitution. I really did not get the second limb on how you crafted the question, my Lord.
I said, is it time for us to propose a legislation to give governors time within which to challenge the decision before somebody takes over their office after impeachment?
I think that will be natural justice, my Lord. That is given time, because you're saying that immediately after impeachment, let's talk about the deputy governor takes over.
Yes.
And then the governor had not exhausted the appeals, or had not even started the channel of appealing against the decision of the Senate.
Yes.
That it is a high time we give them time to exhaust those channels, and with a time limit.
Which means, if he cannot be disqualified from running for a second term, cannot be disqualified from running for a second time because he has exhausted the mechanisms provided under the Constitution, does it go without saying that he also does not lose his office within the first or second day of impeachment? Is there timelines which we must provide? The fact that there is no timelines after impeachment.
I think so, my Lord. I think that is an issue where one has to really think deeply about it.
Okay.
Yes.
Again, on impeachment, and if it's difficult, you don't need to answer. Under Article 145C, 1C, one of the grounds for removal of the President of the Republic is for gross misconduct. Under Article 181, 1C, which is also similar in terms, among other issues, is abuse of office or gross misconduct. For the president, the word abuse of office is not used under the Constitution. But for the governor, both the word is abuse of office or gross misconduct is used. Do you have any reasons for that? Or any proposals? Or your views?
I think abuse of office will call for a higher standard of proof. Gross misconduct maybe could be taken at almost face value as long as it can be proved that it was gross misconduct. That's my thinking about it.
Okay. There is a debate about whether a speaker or a governor is an employee. Therefore, the labor court has jurisdiction or has no jurisdiction. Are you aware of that debate?
No, I'm not aware of that.
You are not aware of that debate?
Yes.
Okay, so I will not ask you that. And this is my last question. If I tell you that the biggest threat to national security in our country is tribalism and or nepotism, 2, populating wrong people in a sensitive places, and thirdly, the way we conduct our elections in that priority, among others, and then other things follow. Will you agree?
Yes, I do.
Thank you very much. I wish you well.
Thank you, my Lord.
Council, you don't want to elaborate a little bit?
Yes.
With what Judge Wasame asked, or you're okay?
I'm okay, thank you.
Okay.
Yes.
Thank you very much, Council. It's now the time for Honorable Commissioner Judge Majaja to continue with the questions. Judge Majaja.
Thank you, Chair. Good morning once again, Council.
Good morning, my lord.
Part of my task is just to look at your sample writings. You presented 6 samples. One was a written submission in a land case at the Kajiado ELC. Second one was election petition Kajiado West, a submission for one of the respondents. The third submission was a running down case at the Kajiado Magistrates Court. Then you presented 2 submissions on a no case to answer in respect of the Magistrates Court, and another submission in opposition to an injunction application in a succession court in Nairobi. I must say that the submissions are clear, well written, and I will ask you questions related to not necessarily on the subject of the case, but technical issues surrounding what you have written and from your own experience as set out in your CV in relation to the work you do. First, I just want to follow up from what my colleague, the Chief Justice, Deputy Chief Justice, asked you about the Supreme Court. That's an important court. Have you had a chance to read the strategic plan?
No, I've not had a chance to read the
You have not had
plan,
a chance to read
yes.
the strategic plan. Have you read the judiciary strategic plan?
I've glossed over it.
You've glossed over it.
Yes.
Okay, but you worked in management positions before?
Yes, I've done so.
Okay,
Yes.
so just tell us very briefly what you understand by the term knowledge management, and how it relates to the work of the Supreme Court.
Yes. Thank you very much, my lord. Yes, knowledge management to me literally means you must, like if it has to do with Supreme Court, you must have sound legal understanding of issues in terms of knowledge, in terms of reading, maybe in terms of paperwork and all that, so that you can be able to apply the same in upcoming cases that may be brought before you.
Okay, thank you. You were involved in the constitutional making process.
Yes.
As one of the commissioners. So probably you can tell us what is the doctrine of judicial deference, the doctrine of judicial deference, and in telling us what it is, probably would give us an example from decided cases in the High Court, Court of Appeal, or Supreme Court, and what is its constitutional basis. The doctrine of judicial deference as it applies to the Constitution, and any examples of that deference from decided cases within this jurisdiction.
Maybe, Your Honor, my lord, you can give a guidance a bit on what...
Okay,
Yes.
what do you understand? What do you mean by defer? If a court says it is deferring to another institution, what is that? Or let me put it this way.
Yes.
A court can say that because this subject matter is being dealt with by another institution, we will not deal with the issue. Basically, I'm giving you the answer. That is called judicial deference.
Yes.
So the court may say, we are not dealing with this matter because there's another institution.
Thank you.
So having given you that answer, can you tell me what is the constitutional basis of that kind of doctrine, and whether you know of any cases that it has been applied either in the Supreme Court, Court of Appeal, or High Court?
Yes. What comes to my mind, if I get that very well, is where I don't know whether it was in the Supreme Court, but I remember a ruling that was given by the court. The court said we may not want to deal with this matter as it is before us right now, because the same can be dealt with elsewhere. It was a political issue. I think it dealt with nomination of members to a political party, and the court put its hands up and said, no, you go to the political parties tribunal. I remember there was a matter of that.
So on what basis, what constitutional basis is that kind of doctrine founded on? And why do you think it is important sometimes for the court to differ?
Could it be separation of powers?
Okay. Let me go to the next question. Again, this is from your position at the Constitutional Review Commission. The Supreme Court occupies a very important role in the hierarchy of the courts in constitutional cases. There is a phrase in section 259(3) of the Constitution that says, in interpreting this Constitution, every provision of the Constitution shall be construed according to the interpretation that the law is always speaking. That the law is always speaking. What do you understand by that term in terms of constitutional interpretation?
Yes. When interpreting the Constitution, you look at it from a very holistic approach. And the holistic approach is the doctrines that the makers of the Constitution and the people wanted the Constitution to be made, that is Wanjiku, wanted the Constitution to safeguard, so that it brings issues of values, integrity, impartiality, equality, and all that, so that as you're interpreting the Constitution, you look at it from all those global areas to give it a living, to be a living, not only in paper, to be alive to the needs of the people.
Can you give us one case that demonstrates that principle you're saying, one decided case of the Supreme Court?
And that one, I can also give the case of Murwatetu, because then when the Supreme Court ruled that the judges or the magistrates' hands should not be fettered in terms of their own discretion, then it was giving effect to the fact that once a matter has appeared before a judge or a magistrate, then they can use their discretion in terms of sentencing. And I think it captured the values of that interpretation and also the dynamism of the society. We are dynamic and we're moving on.
Yes. Now that you have mentioned the Murwatetu case, which I'm sure if you have been watching the interviews has been really the subject of discussion, can you tell us what specific constitutional provisions or doctrines that the court are used to arrive at that conclusion you are talking about?
Please, may I
Yes.
get the question again, my lord?
You have said what the Murwatetu decided, that it gave magistrates discretion. Of course, that was on the basis of certain provisions of the Constitution.
Yes.
So can you tell us what provisions of the Constitution are these the court interpreted to enable it reach that conclusion which you have talked about?
Oh, yes. I think the basing on the fact that the Constitution per se does not provide for a death sentence. And here we have the Penal Code, was it Section 204, providing for the death sentence. And also the other issue is once a judicial officer, a magistrate, or a judge would have gone, if we look at the issue of discretion, what happens when it reaches the point of sentencing? What is it that mitigation in sentencing, what will it help once the sentence is mandatory death sentence? So then it takes away the powers of the magistrate or the judge from really looking at what these magistrates could have been able to do with the mitigation. Another point also touching on that is different circumstances may be looked at, because yes, we can have the penalty saying death sentence is, murder, mandatory death sentence is, for murder, mandatory sentence is death.
So,
but
Counsel, maybe
yes.
Just to redirect you, my question was specific. The court, the reason why the matter reached the Supreme Court is because it raised constitutional issues. So I was asking, what is this? Tell us just one provision of the Constitution that the court was expounding in order to reach the conclusions which you are talking about.
Yes.
Just one provision.
Okay. Provides that justice should be arrived at from looking at issues and arriving at it fairly and equitably, depending on the facts of the case.
Okay. Is there a specific article of the Constitution that deals with that particular aspect?
I may not mention the specific article, but I know in my mind.
Which substance? What is the substance of that article? If we don't know, say the number, maybe the substance of that article that says the court should do what it's saying it's doing. Article on fair trial?
Yes,
perhaps?
article on fair trial.
Okay.
Yes.
Let me move on to another substance of another experience which you have had. Yes. You were a member on alignment of higher education to the Constitution.
Yes.
Which means, and I guess you familiarized yourself with the education system. You looked before you, if you are looking at higher education, you looked at the education system, so you understand some of the issues that we deal with, and you are a parent also, isn't it? So, the question I want to ask, to Article 27 of the Constitution, which is a pivotal provision, talks about equality and freedom from discrimination. That is an article I'm sure you're very familiar with. Yes. So I want to ask you, we have just completed KCSE, and government has a policy of restricting the number of pupils from private primary schools who can join national public secondary schools. Am I right?
Yes.
Yes. So how is that provision justified in light of Article 27? Can you just elucidate to us?
Yes. I think what the government actually is doing is to ensure there is fair access to education for all. And fair access to education for all is looking at, and if I take you back, my lord, to what we did in the task force, is like we were looking at these regions that they may have had not even TVETs. And the propelling factor was, let us ensure that we have colleges that is universities, TVETs, to be put up in these regions so that we bring the issue of we do away with the issue of feeling that others are marginalized. So that is where we are coming from, that to espouse diversity, let us move also the universities to other regions other than having them concentrated in areas that were well known to be concentrated. And when you raise this issue of education, my mind is very clear. It's still the same issue of diversity. Can we have almost an equal sense of education to each and every child?
So what is the term used in Article 27 for that kind of intervention?
Can I maybe look at the Constitution, my Lord?
Well, the answer is there. Maybe look at it. It is called affirmative action. So I'll move on to the next question. You have, in one of the cases you provided for us, in one of the cases was an election petition, Kajiado West. And from the jurisprudence of this, in fact, I would say, if you look at all the reported cases of the Supreme Court, a third of them are to do with the election petitions, isn't it? A third from the time inception. The question I want to ask is, one, does the Supreme Court have jurisdiction to deal with a third appeal emanating from a petition of the magistrate court in respect of a member of a county assembly? And if so, why?
Yes, a third appeal emanating from a member of the county assembly. My Lord, I think the factor here that runs through is also the issue of time. The time given for the hearing of this petition from maybe the lower court up to the time it reaches the appeal court.
So let's take it step by step. So in the magistrate's court, it will take how many months?
I think there's a blanket number of months that was given, 6 months for all.
Okay.
Yes.
6 months. And then in the High Court?
Depending. Maybe even they can take the 6 months in the magistrate's court.
Okay. Then you appeal to the Court of Appeal. How long?
If the time has run out, I think there would be a problem doing all those appeals.
So your understanding is that because of the time frame, the Court of Appeal and Supreme Court may not have jurisdiction?
Because of the time. They may
not,
as of what I see.
Okay. So if you prosecute your case fast enough,
yes,
you would be able to get to the Supreme Court?
No.
So what is the distinction? You tell us.
If it has to go to the Supreme Court, then it's just on those two issues of actually it should be on that issue of interpretation only.
Yes.
But otherwise, it doesn't have to go to the Supreme Court.
So, what is the jurisdiction in a third appeal to the Supreme Court? So, does the Supreme Court have jurisdiction to deal with a third appeal?
Depends on the circumstances. What are the issues that
tell
have
me
been
the
raised?
circumstances.